Good afternoon, everyone. My name is Alex Megaris, a partner in Venable's New York office and part of our advertising and marketing law practice group. I am joined by my colleague, Len Gordon, who heads the advertising and marketing law group here at Venable, and also formerly served as the Federal Trade Commission's Northeast Regional Director. Today, we will be covering the proposals that the FTC recently issued to change the endorsement and testimonial guides. We'll talk about a few. Apologies. We will cover just some basics with respect to the existing guides, which were first published in 1972. Len will then discuss a little bit about what's going on at the commission, what's driving the proposals that have been issued. And then finally, the meat of today's presentation will walk through what exactly the FTC is proposing to change. So what are the endorsement guides? Certainly don't want to spend too much time on the existing guides, but they serve as a good baseline to understand exactly what may change if the FTC adopts them as proposed. First published and issued for public comment in 1972, they are the staff's interpretation of what constitutes unfair, deceptive endorsements or testimonials. They have been reissued or relooked at first in 2009 to address the rise of social media and endorsements done through posts and other social media platforms. And then in 2020, right before the pandemic, the FTC embarked on a request for information to see if it made sense to make changes to the guides, to ask the public what the costs and benefits have been of the guides. And that's what, after a couple of years, the FTC has issued now its proposals. The existing guides define endorsements very broadly to mean any advertising message that consumers are likely to believe reflect the opinion or belief or experience of a party other than the advertising sponsor. In addition to the actual guides, which again are advisory, it's advisory in nature, not a formal rule, which means that the FTC in an enforcement action would need to prove that the specific practice that violates the guides are in fact deceptive or unfair under Section 5. In addition to the formal guides, the FTC over the years has provided less formal guidance on how the guides apply to specific test cases, and through a FAQ of sorts on the website, updates them pretty regularly. They also have issued a few documents, most recently about consumer reviews, and those platforms, we'll talk about those. First principle with respect to the endorsement guides is that endorsements must be truthful. So they must reflect the honest opinions or experience of the endorser and should come from an actual user of the product or service that's being endorsed. And importantly, must be a bona fide user of the product or service at the time that the endorsement was given. The FTC has said that an advertiser may continue to use an endorsement so long as it has good reason to believe that the endorser still is a user of the product and stands by the endorsement. FTC has also said that an endorsement that is represented to be from actual customers should either utilize actual customers or disclose that the persons in the ads are not actual customers. And in these proposals, as we'll discuss, the FTC has made some additional recommendations with respect to use of actual customers. And then although endorsements don't need to be verbatim the exact words of the endorser, the endorsement cannot be presented in a way that distorts the true opinion or experience. The second key principle with respect to the endorsement guides is that any claims made by the endorser must be substantiated. Endorsement can't convey a representation about a product that would be deceptive if made directly by the advertiser. And the add-on there is that as a result, the advertiser must have adequate substantiation, including competent and reliable scientific evidence as necessary to support the claims made through the endorsements. And so any performance or efficacy claims made by an endorser must be supported as if made directly by the advertiser. And then, of course, not only do you need to have substantiation to support the claim made by the endorser, but also substantiation in that endorser's experience with respect to a key attribute of the product is representative of what customers will generally achieve with the product.
Can I jump in for a second?
Please.
So in 2009, when the commission last revised this typicality issue was probably the biggest issue, or one of the biggest issues in the revision. Up till then, advertisers frequently used results not typical and thought they were safe there. The 2009 revisions to the endorsement guides did away with that. In this current proposal, the FTC revisits that, and they apparently did some copy testing to see how consumers interpret these kinds of typicality disclosures. They, in a footnote, mentioned that results not typical does not change the impression that most consumers take away from a endorsement, a testimonial, that the experience of that testimonialist is typical. They also found that even a stronger disclosure, not likely to have similar results, really pretty strong disclosure, also was not effective. Now, the FTC has not made the results of this copy testing available, and in that footnote, they note that it will depend on the circumstances, and they have ultimately the burden of proving that the use of the testimonial or the endorsement was ultimately deceptive. But you should understand that their going in position is going to be that, for the most part, you can't. It's very difficult to disclaim the typicality implication when you use an endorsement or testimonial, and that really comes in with earnings claims, probably, and weight loss claims are the two areas where those are most commonly used, and where the FTC most commonly has issues.
Thank you. And so as a result, the FTC expects the advertiser, to the extent that the endorser's experience is not typical, to actually disclose what a typical customer would expect, which is a pretty high burden for advertisers. Third principle, material connections must be disclosed. So any material connection between itself and the endorser that may influence the reasonable consumer when they're viewing or the endorsement or trying to attribute weight to the endorsement would not expect needs to be disclosed. And we'll talk about some proposals the FTC has made with respect to social media disclosures. And then finally, with respect to expert endorsements, experts need to be qualified. So if an advertiser represents that the endorser is an expert, then the endorser's qualifications must be able to give the endorser expertise that he or she has, representing as possessing. The endorsement must be supported by actual exercise of the expert's expertise, including examining or testing the product as extensive would be required to support the conclusions in the endorsement. And if the endorsement involves a comparison, the expert must have evaluated the product that it's being compared to. So I'll turn it to Len to talk a little bit about what's driving these proposals.
Thanks, Alex. Social media is probably becoming one of, if not the dominant advertising channel. some of the other things the FTC is doing with Facebook and may ultimately change that. But right now, that there's an enormous amount of dollars. That's what moves market share. And the FTC is one of the reasons I think they're updating these is just to deal with that reality. TikTok, other platforms weren't even in existence the last time the FTC revised the guidelines. So I think that's one thing that's doing it. Influencers. Influencers, I don't think existed in 2009. If they did, very few people had heard of them. Now, I mean, I have high school, or daughter just got out of high school, and she and her friends all want to be influencers when they grow up, and who wouldn't? So that type of influencer marketing is changed. The influencer marketing, we've had lots of discussions with the FTC about, people know that these influencers are influencers and that they're paid spokespeople. The FTC is not there yet. There's a little bit of wiggle room in the proposed revisions to the guides that say that if, from the totality of the circumstances, a reasonable consumer would know that this person's being compensated, then you don't have to disclose it. But that puts an awful lot of judgment on the part of the advertiser to figure that whether that works or not. An interesting issue is, how is the FTC going to use these guides? I mean, they clearly sort of tighten up and raise the bar for what advertisers have to do. As most of you know, the FTC has lost its ability to obtain equitable monetary relief for violations of Section 5 through Section 13B of the FTC Act. That was the way they often went after, deceptive advertising involving endorsements and testimonials. Because of that, the FTC revived its penalty offense authority late last year. They issued letters to over 700 of the country's largest advertisers, putting them on notice that deceptive endorsement and testimonial practices had been found to be deceptive, not disclosing material connections, not disclosing or implying that someone used the product when they hadn't, all the sort of the top 10 that Alex went through a minute ago. The FTC sort of cobbled together previous FTC adjudicated administrative decisions and created a notice of penalty offense, and it sent it out to these marketers. What will be curious is to see if the FTC starts pursuing marketers under its penalty offense authority. And as the name implies, they can get civil monetary penalties for violations of this. Whether they'll use the interpretations that are captured in the new endorsement and testimonial guides to challenge the endorsement and testimonial practices. So essentially sort of combining the notice of penalty offense authority, which has sort of vague language in it about what is deceptive, with the much more specific guidance in the guides and using that to try and impose civil monetary penalties. I don't know if they're going to do that. I suspect they may, because they are doing everything they can to figure out ways to get money from the companies that they are pursuing. So we'll see if that happens. So let's talk a little bit about some of the big picture changes that the FTC has offered. And I should note, and it's a little curious, this proposal went out over a month ago.
May 19th.
Yeah, in May. It has still not been published in the Federal Register, which sort of triggers its the comment period, as you can see on the slide. I haven't heard why that is. I mean, we can suspect that perhaps there's further revisions. Perhaps they're thinking about doing something else. You don't know if the arrival of Commissioner Bedoya has something to do with this. It would all be speculation, but it's odd that given the amount of time they put together in creating the updated guides, that they then are now waiting almost 2 months to put it in the Federal Register is just odd, for lack of a better term. And the longer it is, the more suspicious you get that there's going to be something else that happens, whether they try and turn this into some kind of a rulemaking procedure or make some significant revisions to the guides. And there's one other thing that we'll get to in a second that maybe that's what they're waiting for, but we'll see. So some definitional changes. They clarified liability for advertisers, endorsers, and intermediaries. I don't think there's really anything new there. It's just more of a clarification. Consumer reviews are dealt with a little bit more directly and a little bit more extensively in the update, and I think that's a factor of reviews becoming more and more important in consumer decisions. And the FTC is trying to track what moves the needle for marketers. They are suspicious of endorsements and testimonials and suspicious of consumer reviews because their view is that consumers are not suspicious of those things, that consumers trust endorsements, testimonials, and reviews more than they trust an ad that you would see on network television where it's an ad. The difficulty sometimes, at least for the FTC's view, people being able to discern that what they're reviewing is an advertisement is what drives much of this. And that's something, as you're thinking about whether something ought to be disclosed and whether something is adequately disclosed, would a reasonable consumer understand that the statement that this person is making, they were paid essentially to make? Talk about a little bit about endorsements directed to kids, and then how to disclose material connections. So the revisions make clear that tags in social media posts can be endorsements. That was certainly the FTC's position in our experience, but now the guidelines make that clear. They refine the definition of an endorser to indicate that endorser could simply appear to be an individual, group, or institution. So phony endorsements made by bots or fake social media accounts are now within the definition of endorser. Again, I'm not really sure that was necessary. If someone's making phony statements, you would think that's on its face deceptive, but now the guides more overtly cover that. The definition of clear and conspicuous as it relates to disclosures and disclaimers was modified slightly. They stress the importance of unavoidability. And so that goes to not just the initial disclosure on social media, but if posts are forwarded, that disclosure's got to travel with the message, the advertising message. It can't be that once it's forwarded, you don't see the pound ad or paid spokesperson or whatever tag that endorser is using to let people know that they're getting paid for this. There's a pretty fulsome discussion of the media in which a disclosure or disclaimer has to appear. If the triggering claim is visual, at a minimum, the disclosure needs to be made in the visual portion of the endorsement. And if the claim is audible, at a minimum, the disclosure should be made in the audible portion. And not surprisingly, the FTC thinks that doing both, belt and suspenders, is best, but that's a decision the advertiser is going to have to make depending on real estate and the media. One of the things that's a little bit more explicit in this version of the guides, but is sort of a basic premise of FTC false advertising law, is that when an endorsement targets a specific audience, the effectiveness of the disclosure will be evaluated from the perspective of a member of that group. So a couple groups are probably immediately brought to mind, and they're in sort of the opposite ends of the age continuum. Children, and we'll talk about that in a little bit, because that's an area of real focus and increased and further focus by the FTC, and also the elderly. If you're targeting people with products that supposedly reverse or stave off age-related mental decline, dementia, things like that, that's a vertical that the FTC has been very active in, but the disclosures need to be something that if you're using social media to attract those kind of people, you need to make sure that they can understand that someone's being paid, or if there's important limitations on what you're claiming, that needs to be clear and conspicuous. Also, the other sort of obvious example here are foreign languages. So if your ad is in Spanish, your disclaimer needs to be in Spanish. If your ad and your endorsement is in Korean, your disclaimer needs to be in Korean. You can't make the claim in something other than English and then have the disclosure in English. That's not gonna work. Endorsers, influencers. So excuse me, the FTC has gone after endorsers and influencers in the past. I mean, they did it. Former baseball player Steve Garvey a long time ago. And when they're going to tag an endorser and an influencer, excuse me, is when that speaker knows or should know that their claim is deceptive. So if they're saying in their endorsement that they used a product and they didn't, they know that. If they're talking about their results and they don't really know that their results aren't typical, then they may be able to get away with that. But it's going to depend. If they're making disease claims, could be more problematic. For example, there's an example in there about a skin lotion, and the testimonialist talks about how it cured their eczema. Well, eczema is a disease. So the FTC is going to say that you need to show that that's a typical result of somebody that uses that product. And in that instance, the FTC is going to, at least is reserved this right to go after the influencer, because their view is if you're making a disease claim, you need to have a basis to say that others will have the same result. If you're a medical professional and you're making endorsements, the FTC is going to expect that you know better about things that you shouldn't be saying. If there isn't real science behind a product, but you're claiming that it can cure something or alleviate something that is a disease in the view of the FTC or the FDA, you're going to have problems potentially. And then failing to disclose unexpected material connections between yourself and the advertiser. You know if you've gotten paid, you know if you've gotten a truckload of free goods, and you presumably wrote your post and know whether you've disclosed that. So again, that's something that the influencer does know and should take responsibility for making sure it's disclosed, because I do think the FTC is going to get more aggressive going up against influencers. I think they think that's one way to sort of chill some of the really aggressive behavior that they're seeing. The FTC in the guides also talks about their standards for going after intermediaries, ad agencies, and PR firms. The FTC has done this in endorsement testimonial contexts and in other contexts before. Again, obvious claims, I think, are the ones that are going to get the FTC's attention when they go after ad agencies. And especially where a lot of companies are relying on ad agencies or consultants to manage the relationship between the marketer and the endorsers. And that includes making sure that the endorsers are making disclosures about compensation and also other material connections. That's something that the FTC, I think, is expecting ad agencies to do a better job of policing. And if they don't do that, especially consistently, and especially if there's some evidence that they know they're not doing that, I think that's an area where you'll see intermediaries getting tagged.
I think with this, the FTC was getting tired of everyone playing hot potato, blaming each other for not knowing the responsibilities. And when you have influencers that are not doing their own posts and are relying on PR firms to create the post for them, and they were failing to add the disclosure, the FTC is now saying everyone can be responsible depending on level of knowledge, or if you're deliberately not trying to know what's going on. Len mentioned in his road map for what is in these proposals, the customer reviews and the FTC's attempt to address them more directly. They have very specifically said that when advertisers or third-party platforms are involved in procuring, suppressing, boosting, organizing, or editing reviews of products, that you should not take actions that have the effect of distorting or misrepresenting what consumers think of the products. And basically what the FTC is saying, and this made some news in the winter when it brought an enforcement action against a company for suppressing negative customer reviews, and then followed up with two guidance documents, one for advertisers, one for the review platform, saying essentially what has now been put in these proposals, which is you cannot suppress negative reviews because they're negative. and that you need to treat both positive and negative reviews equally. And so while you're not required to display reviews on your website that contain, unlawful, obscene, harassing, vulgar content, you have to apply that gating policy to both negative and positive reviews equally. The FTC has also said that while you're not required to display reviews that are unrelated to the products and services, it explicitly says that services surrounding the product, including customer service, delivery, return policies, and experience with returns and exchanges, is related to the product and service. And so excluding customer reviews that are about customer service or delivery and return policies, et cetera, is not an appropriate basis. But in the proposals, the FTC does ask the question, because again, this is proposals. The FTC is seeking public comment on these proposals. It expressly asks the public, do consumers expect that sellers publish reviews that are just about a product, shipping, a refund product practices, or customer service together with product reviews? And I think what the FTC is trying to understand is whether it'd be sufficient, for example, if reviews about just customer service were segregated from the product displayed, but segregated, if that would be appropriate.
And I mean, this is a real reflection of what's happened in the economy in the last 3 or 4 years, whether you're talking about fast fashion or same day delivery, and just the enormous amount of goods that are now purchased and then delivered, as opposed to, people looking online for things and then going to a traditional brick and mortar. The experience part of service part of the purchase is important. It's like going to a restaurant and having, a really rude waiter or so. I mean, I am highly suspicious that this will end up being all part of the same practice if the goods are being sold, by mail order or delivery, because that's just part and parcel of what people are buying. And essentially, the other half of this is that the FTC, sort of the way it is done with substantiation, they found that when you make a claim about a product, you are making an implied representation that you have a reasonable basis for that product efficacy claim. They're finding that when you post customer reviews, you essentially are representing that these reviews are either all or a very representative sample of all the reviews, and you can't cherry pick anymore. I know a lot of companies are struggling with this, but it's kind of all or nothing. You don't have to post reviews, but if you do, you got to produce them all. And again, the reason for this is the FTC thinks that people rely on these. And, if you're only producing the 4 and 5 star reviews, you're really not giving an accurate representation of what customers think about your product. And that's the problem.
I think this is going to be one of the more controversial aspects of the proposals. I mean, the FTC goes so far as saying, do not ask for reviews only from customers who you think will leave positive ones, which, who's going to ask someone that had a negative experience to leave a review? And I think this has a lot of implications for companies that engage in what they refer to as reputation management. And even SEO seems to be something the FTC is very wary of and thinks it can be potentially deceptive. And so I think this area needs to be looked at very carefully by industry. And similarly, review sites. The one thing that the FTC has targeted expressly in these proposals is review gating. Review gating is when you lead potential reviewers, customers down different paths depending on how they answer a gating question. Typically, did you like the product, or would you refer this to a friend? And if you say no, then you're going to get sent down a different path. If you say yes, you'll be asked to submit a customer review. I think we've all gone through that in our personal shopping experience. Here, the FTC is saying review gating is deceptive if the result is that the posted reviews are substantially more positive than if the advertiser did not engage in gating, which of course is a very difficult standard to meet, because that means you'd have to test to see if you're doing it, if you're not doing it, if it's about the same number of positive reviews. And if review gating was effective, then it should have the effect of having more positive reviews. So basically, it's not okay. Also, comparison shopping sites are very popular. They work really well in terms of search engine optimization. FTC is aware of that, and they are saying that setting up an apparently independent review site that reviews the seller's own products and competing products is inherently deceptive. And similarly, with respect to actually independent review sites, paying to pay to play, paying to boost your ranks on a third-party review site or comparison site is deceptive, even if there's a disclosure, if the website doesn't claim to be independent or be objective, and it's obvious that it's a pay-to-play situation. That's inherently deceptive. The FTC does recognize, and this is why we have that New York Times Wirecutter, that so many of these review sites, make their income to pay for the reviewers and all the testing that they do by getting by sending affiliate traffic and making commissions off of purchases. There, the FTC says it's okay, but it has to be clearly and conspicuously, as newly defined, disclosed that is what is happening. We talked in the opening slides about the existing guides, and one of the things that we commented on is that if the endorser's experience is not representative of what a typical consumer is going to experience, you have to not only disclose that, but you have to disclose what is generally expected, what is a typical experience. The FTC in these proposals have added that the disclosure itself, the disclosure of what is generally expected, has to be presented in a manner that does not itself misrepresent what consumers can expect. And in this section, the FTC provided a number of examples as to what they mean, and this one I thought was did a good job of capturing what the FTC is getting at. So if you have an endorser for a diet and exercise program that says, I lost 50 pounds in 6 months, and the ad discloses that that's atypical, and that the typical person who uses and sticks to the program for 6 months is 35 pounds, so actually less than the endorser. The FTC says that disclosure can still be deceptive if, for example, only a fifth of the people who use the program actually stick with it for 6 months. So there's a condition precedent to even get there. So that disclosure is inadequate from the FTC's perspective. And there's other examples that are helpful to review with respect to these types of disclosures that in and of themselves create deception. Before we move on, we want to give the CLE password because we always forget to give it. And that password for the CLE credit is Endorsement 2022. Endorsement 2022. Disclosure of material connections. Of course, the existing guides and the FAQs that the FTC staff has posted and updated over the years go into incredible detail about what is appropriate disclosure. The FTC, a couple of years ago now, issued a specific guidance document to influencers that's very easy to use, that kind of goes through all the different kinds of social media posts that were available as of 2 years ago and what a proper disclosure looks like. But here in the proposals, the FTC makes a few points. First, material connections are more than just monetary payment or compensation. It could include a business, family, or personal relationship, and those do need to be disclosed the same as if you're receiving compensation for the post or other type of endorsement. Free or discounted products to the endorser, including products that are unrelated to the endorsed product, is a material connection. And so if an advertiser is working with a celebrity and they offers sell an array of products, if the endorsement is for the soda, but the endorser is receiving free water from the company, that is a material connection when posting about the soda. Same thing, early access to a product, and this is really big in the gaming world where you're getting kind of sneak peeks and early access. That is considered a type of compensation, a benefit, and that would trigger the need for a disclosure. And the possibility of winning something, the possibility of being on a show or being paid or hired for something, that too, according to the FTC, would trigger the need for a disclosure in an endorsement.
I mean, anything that you can think of that might cloud the endorser's judgment, or that the consumer would want to know before they consider what weight to place on this particular endorsement or testimonial, is something that's got to be disclosed. And it can be cumbersome, but if you're going to rely on these types of things to market your product, you've got to sort of systematize having these material connections disclosed, because this is one of the areas where the FTC is most vigilant.
And then the FTC also states that a connection can exist regardless if the advertiser is providing this benefit, early access, free product, discount, whether it requires an endorsement from the person receiving it, even if it's just a gift with no strings attached. If the recipient wants to talk about that product or even unrelated products, a disclosure will need to be provided. In the examples that the FTC provides to highlight these concepts, it discusses where a celebrity is, a paid endorser of a product. So, for example, let's say a television commercial or some sort of, live event endorsement. If the celebrity then on her own decides to post on her social media page a picture of that event or just any type of mention of that product, that post still needs to have the disclosure, even though it was not part of the deal that was originally negotiated between the advertiser and the influencer / celebrity. A couple of other examples that are helpful to understand what the FTC is thinking here. If a celebrity is on a talk show and he or she is talking about, for example, she's an athlete and how her game has been so good because of the use of a new pair of sneakers, and if she is being paid by that brand, she needs to disclose that during the talk show, like during the live presentation, not in credits at the end of the show. So it needs to be embedded in part of her messaging while she's being interviewed.
And she needs to be careful about the kind of claims she makes. If she starts making injury or pain relief claims, that crosses the line, and it's a little bit more challenging when you're talking about a talk show because it's not as scripted and not as easy to review beforehand as a social media post might be, or a video that goes on social media might be.
And the last point, what the FTC says that the specific nature of the relationship does not need to be disclosed in details, but it needs to, one, be clear and conspicuous as newly defined, but also clearly communicate the nature sufficiently for the consumers to evaluate its significance. And the example that they provide, I think, is interesting because I would never have gone there. So the example is, if there's a television ad for an anti-snoring product that's featuring a doctor who says, I've seen dozens of products like this, and this, in my opinion, my professional opinion, is the best. Consumers clearly would know that that physician is being paid, and the commercial itself does not need to disclose that, Dr. Smith is a paid endorser. But the FTC says, however, if the doctor is also receiving like a percentage of sales, that would not be obvious, and that would need to be disclosed in that television advertisement. So from the FTC's perspective, that connection is not obvious, and it would, in consumers' mind, be impact their weight that they would assign to it, in addition to the fact that they already know he's being paid to talk about the product in the advertisement. So any type of kind of something that's not obvious needs to be disclosed, even if it's clear that it's an advertisement.
But the disclosure has to be obvious. And one of the
Clear and conspicuous.
one of the fights that we have frequently with clients, and clients have with their talent, is that talent will find pound paid or pound ad to be tacky. And like, well, it makes it seem like this is an ad, and well, it is. So that's just a fight you're going to have with your talent, and you can massage it a little around the edges, but the user has to understand that the testimonialist is being paid for what they're saying, and it's just a constant struggle. Or they have to make claims that are just general about the product, and it makes it a little easier.
And with that, let's talk about the last section that
Right.
the FTC has in its proposals, which is a big placeholder.
It's a huge placeholder and could really change the way marketing is done to children. There's a placeholder right now at the end of the proposed guides about marketing to children, but there's not really any meat on the bones yet. They've issued a call for additional information. They're going to have a workshop on October 19th to address this. They're going to consider, how children develop at different ages and their ability to understand and recognize advertising content, and distinguish it from other content. They want to consider the harm to children resulting from that inability to recognize advertising. What do you do to protect children from the blurred content? Native advertising is the word sometimes thrown around. And then what kind of disclosures would be efficacious for kids? If kids just generally don't understand that something's an ad, how do you disclaim it so they do? And what involvement does there have to be of parents in all of this, and how does a marketer deal with all that? So there's a lot on the table. I think the October 19th event will be really, really interesting. If you're a company that markets to children, you ought to be thinking about this now, especially if you use social media. Kids at younger and younger ages are getting social media accounts or using their parents' social media accounts. And so you need to be thinking about this, because they're going to do something. I think what is unclear, but it could really change the way children are marketed to.
Len, why did the FTC do this? Why did they not wait to get everything they needed on children endorsements? Or why didn't they just do it in two separate?
I don't know why they did it in two separate. I don't know if it had something to do with the timing of the Bedoya confirmation and they wanted to get something out. I found it odd that they went through all the work to redo the guidelines, and then what would possibly be the biggest change they sort of punted on. So I don't know if they're getting pressure from staff to do this or getting pressure from the Hill to at least do something, but I thought it's curious, and because it's curious, it makes me nervous.
So essentially, there's going to be another round of proposals after some point after the fall.
And you know, like we said at the beginning, but it's worth reminding you that these are only
Yes.
proposals. Great minds work. Like, so there's an opportunity to comment. The comment period has not started yet. It'll be within 60 days of when it finally gets published in the Federal Register. The review time under the OIRA regulations, I think, is 10 years. That it likely get looked at again. It could happen sooner. Probably wouldn't happen a whole lot later. So if you're a marketer and you've got concerns about what you've seen in the proposals or what you heard today, you should express yourself, because if you don't, you're sort of losing your last chance. I don't know how much the FTC will alter what's out there. These things were not done quickly, but there are certainly things that they may not have thought about, or some balancing that needs to be done. So if you've got views here, you really ought to make yourself heard.
We've received a few questions. The first one I'm going to direct to Len.
Thanks.
Can you talk more about earnings disclaimers as they relate to financial industry?
Yeah, I could talk for hours.
Financial
about that.
publishing industry.
Yeah. So the FTC does not like earnings claims. They think if you're going to make earnings claims, they want you to do tracking of everybody who buys your product and the results that they've experienced, and that's generally not something that companies can do. They don't have metering or monitoring mechanisms in place to track the results of every person. You can't do this in a clinical trial like you might be able to do for a dietary supplement. So that's a fight Alex and I are having with the FTC in cases now. It's a fight other people have been having. At some point, the First Amendment comes into play. If the level of substantiation that the FTC is requiring for earnings claims is so high that no one could ever satisfy it, that essentially outlawed that kind of claim, and that including truthful claims, and that obviously implicates the First Amendment. Those arguments have been raised in cases. They haven't gotten fully litigated yet. That may change. Some of that's through endorsements and testimonials. That's one of the ways that those kinds of claims get made, but there's other claims just more directly where those kind of claims get made, and the issues really are the same. And the typicality issues that we talked about are huge there, because if someone gets trained to do something or reads something from financial publishing and learns how to do something, somebody might apply it very diligently and really follow what they're taught. Someone else might not. It's really difficult for the marketer to track those differences. So you've got it, but as a marketer, you've also got to avoid making claims that this is easy, everybody can do it, everybody makes money. So there are some things that the marketer can do to protect themselves, but at a certain point, it gets pretty gray and pretty sticky.
I will take the next one. The question is, in many situations where a benefit is provided with no strings attached, there's not going to be a contract. Under those circumstances, beyond advising the influencer that they need to disclose, what can be done to mitigate the risk? And so advising the influencer of his or her obligations is essentially what the FTC expects of advertisers that work with influencers, and has said so in these proposals, and also over several enforcement actions it's brought against companies that work with influencers. But the most important thing you could do is not repost any posts that are non-compliant, because then it will be attributed to you directly. A good program for ensuring compliance that for a company that works with influencers on a regular basis will include contractual terms that will, and advising the influencers of their obligation. Second, some sort of monitoring system where you spot check posts, or track who's talking about your brand, and if it's done in a non-compliant way, both from a branding perspective but also from a legal perspective, you should notify them. and then taking action when you identify these, non-compliant practices that don't get corrected by the influencer directly. Otherwise, you're right. There is not as much you can do.
I mean, the way you're offering the free product, the more it sort of insinuates to the influencer that they'll get more of it if they post favorable reviews. I mean, the more of an issue you've got. So
yeah, you have to cut them off.
Yeah.
Another question relates to review sites or reviews. If you pull reviews from a third-party site, but due to space only limit to the most recent reviews, is that good or bad? And I think to the extent that you're applying that practice equally for good and bad reviews, and only uploading or reposting the most current ones, and you apply that uniformly, then that should be fine. I don't think the expectation is that every single review from a third-party site gets put on your website.
I agree.
And then finally, this is not going to get answered in this session, but what's considered adequate substantiation or adequate basis to support a claim, and what percentage do you need to reach something like most customers experience X?
So it's really going to depend on the kind of product. If you're talking about health claims, you need probably random clinical trials. At least that's the FTC's view. If you're talking about earnings claims, they want statistically confident evidence that what the typical result is. The FTC relies on what they call the Pfizer factors, which consider a variety of things, including the risk of a false claim, the difficulty in obtaining the substantiation, some of the things I talked about before. So it depends on the kind of product, but the areas where the FTC is most likely to dive into your substantiation are health claims and earnings claims. And those are the ones where they're really scrutinizing substantiation.
Someone asked recommendations for disclosing an endorser via social media. Is #ad sufficient? So not in the guides or proposed guides, but on that, I say FAQ document that the FTC maintains and refreshes online. There is very specific guidance about how to disclose a connection very specific, including, where exactly it should be located in the post and where it should not be located, what words work and don't work. #ad has been bulletproof to date. It's always been something the FTC.
That at the beginning of the ad is probably the safest thing to do.
And in my view, it's the easiest because it's just 3
symbols.
Thank you. So #ad always will work. There are other options that the FTC has, quote unquote, blessed. Sponsored is not going to be one of them unless you have the brand's full name next to the word sponsor. And same with a whole number of ambassador won't work unless the brand name is also included in the disclosure. And so I would recommend anyone take a look at that document. It's very easy to use, and it does get very specific about which words work and don't work and what abbreviations work and don't work.
#ad is, it's in your face. It's obvious, which is, some marketers don't like it, but it's also short.
Yeah.
So it doesn't consume a large part of the very limited real estate you've got in a lot of posts. So
that said, you can't bury it. So you can't have a long hashtag and then have #ad kind of hidden. It needs to also be prominent, but for the most part, that will work. Should the party that enters into agreement with the influencer authorize the language of the disclaimer or just advise them regarding the need to have one? This is a tough call. What I typically advise clients is to share the document that the FTC itself has published for influencers, to attach that document to the contract or make it almost like an exhibit. It's the FTC's guidance. It's not your guidance. And you don't want to be providing legal counsel to the influencers. And it's a really easy to use document. So I tend to say you should be approving the language, but instead of coming up with their own copy, use what the FTC has said. And if there is a desire to use, something not as hashtag ad, you need to make sure it's correct, but then that your influencers know to use it. So some advertisers do in fact like to dictate what needs to be said for brand purposes. And with that, we will close our webinar. Thank you very much for participating. Once again, the CLE code for credit is Endorsement 22. This session will also be made available on the web at some time soon. And if you have any questions that we didn't get to or that you didn't have a chance to ask, do not hesitate to reach out to us. Our
Thank you
email
all.
address. Thank you.